Okay, it is about 8:31, and welcome. It is Tuesday, March 12th, 2019. Welcome to week 6, the very final week and very final lecture for this course. And I hope that you have learned a lot about criminal law in this course, and that I hope that you are able to understand the principles and concepts, and that I'm going to go over the requirements and assignments for this week, and then I will adjourn. So make sure that this is done to be able to hear. All right, so now I'm going to go ahead and share my screen. Okay, you're familiar with all of this information here. So I'm going to go down to this part, and you can see that each of the lectures are recorded here, and that today is the final lecture, and that if you're not able to attend or attend, we provide you with the keyword. And also, I want to remind you that there is a course evaluation that was sent to you in your email, asking you to take time to complete that. You can complete that by Monday. So if you want to study, then fine, but try to get that completed by Monday or this week if you desire. I appreciate it. It would help us to know how you enjoyed the course and what you learned and so forth. Okay, so week 6, we're going to talk about defenses to criminal liability. And chapter 10, I sent you the PowerPoints earlier in the week of a brief introduction to criminal law. And so we're going to talk about the mental disorder and the insanity defense a little bit about involuntary intoxication, mistake of fact and mistake of law, a little self-defense, and then I'm going to remind you to study the key terms. Study the key terms of your quiz, which is basically your final exam that'll be coming up this week as well. And then practice mistake of law, and then do your practice quiz. Very, 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 very important. I have said that over and over and over again, how important it is that you make sure that you do study that, because it will help you when you get ready to take. One student has already asked me about the final exam. I already said it covers weeks 4 through 6, and my recommendation is to look at the PowerPoints. If you have time to go back and listen to the lectures, remember what your assignments were that you completed as well. So your discussion post, murder or self-defense, your initial post is due tonight by 11:59 p.m. Central Standard Time. And reminder, your reply post is due this Friday, the 15th at 11:59 p.m. Do not say, I thought that the course ends Sunday the 17th. It is not. It doesn't end the 16th. You have had me to talk about this for almost the whole quarter, but I'm drumming it home with you with these highlighted points, reminding you of your written assignment, which is a quiz, which is time. That's your big assignment that you have for this week. Your discussion posts as well, all right? And I'm reminding you again that the quarter does end officially. If you submit anything after that, I won't grade it. Which reminds me, if you submit anything for weeks 1, 2, or 3, I will not grade them unless I've already made previous arrangements with you. At this point, 4, 5, and of course week 6. That's it. That is it. take time to complete the student evaluation that I already referred to earlier, okay? Appreciate that very much. And then I want to remind you of my motto, which you already know what that is all about because I covered that during the course of the first week. So now let's look at our course calendar. And again, as it comes up, you see this is where we are, the 12th today. Shows your initial post is due tonight. Shows you the topic of it, murder or self-defense. Tells you that your reply post is due Friday, as well as your written assignment. What is your written assignment? It's the quiz. It's the time quiz, okay? So I call it a written assignment, and it is. So both of those are due. And then here's a reminder, as I said earlier. If you click on that, reminds you that the quarter ends at 11:59 p.m. Central Standard Time on the 15th. So there is no excuses for when the quarter ends. The calendar tells you, the announcements tell you, the lecture are covered as well. So let's dive right into the module. Let's look again at the assignments very quickly. Your discussion posts, and you know what you're supposed to do by following using the scenario, and then for your initial post, and then your reply post, consider another student's or defend your position regarding both questions as well. Then your quiz is set for 30 minutes. 30 minutes, and you already know the policy about academic misconduct. As far as taking it, you should not have any books open, any materials open. It should be as if you were in the classroom and you were taking an exam and we were together. And then your key word that I'm going to give you at the during this lecture will be needed to be submitted not by Sunday, but by this Friday, the 15th. Okay, or earlier, okay? Let's close this up. Let's close course 2. Okay, so now let's get into the module and discuss what's in here in the lesson content before we conclude. So we're going to talk about self-defense, defense of others, mistake of law, mistake of fact, excuse defenses, and then we're going to deal with deadly force. Okay? And so I'm going to cover the mental disorder or insanity defense, involuntary intoxication, mistake of fact and law, and self-defense. So let's talk about this one. Now, be aware that this is probably a rarely used defense. Reason being is because it is very difficult to provide proof that you did it. Now, it's known as an affirmative defense. Now, when something is an affirmative defense, you're not saying that you did not do it. But what you're saying is that it was justified or you were excused because of the state of mind at the time the offense was committed. Now, as you already know, the standard is proof beyond a reasonable doubt. In certain situations where you admit that you committed the act, but the law provides an exception that should be not guilty despite the admission. So that's what I just said, when you admit it. In order to have an affirmative defense, you have to say, I did it. Same thing applies in self-defense. You have to say, no, it wasn't me that killed him. Then you can't use self-defense. You have to be one to say, yes, I committed the killing. But that is because of, and we're going to talk about some of the standards. So anyway, the state of mind takes away the premeditation or the intention to commit the offense. And it then says that the act was not a crime, even though it ordinarily would be a crime. Now, if a defendant raises the insanity defense, then that person will be found possibly guilty or charged with the offense. And as I said before, it is not a successful defense. I can tell you that in my many years of defending individuals as a lawyer from 78 to 2000, and the many cases I handled, I tried several times to use the insanity defense and was not successful. Even in one of the most heinous crimes that I represented a young man in, his capacity to commit the offense was that he understood what he was doing, and that therefore the insanity defense does not fly. So it is very, 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 very difficult. You're going to find that, and we have at our jurisdiction here what we lawyers call it that anyway, but I'll tell you more about it in a minute, the Amanda Wallace rule. Amanda Wallace was a lady who had a child taken away from her by Department of Children and Family Services, which is a protective service agency for children in our jurisdiction, and the child was returned to her. A short period of time after the child was returned to her, she hung the child, and the child was killed. Well, she was, of course, arrested, and she was placed in jail. Now, I saw her when I went to visit a client of mine, and she was sitting in a corner in a ball, balled up, rocking, and you could see that she was just totally out of touch with reality. And it was determined that she was insane because at the time she committed the offense, she could not appreciate that she was actually hanging a human being, let alone her own child. So therefore, she was found not guilty by reason of insanity. Now, you don't walk out if you're found not guilty by reason of insanity. You're then committed to a hospital or a mental institution and treated, and you remain there until you have a change in your mental state. Some of you may remember John Hinckley. It's a while back. He was charged with attempting to kill the President of the United States, Ronald Reagan, but he ended up wounding instead one of the people that worked with him. And anyway, he was committed to a mental institution, and he remained there for many years. Unfortunately, by some people, he was just released about a few years ago, and he is, I don't know where he is now, but he was released. But he was in the institution for a long time. So the judge then has to approve whether a person is competent and able to return to the community, and he was determined to be that. My understanding is, last word I heard is Amanda Wallace is still in a institution. So the insanity defense takes place in most jurisdictions, except these that are mentioned here: Idaho, Kansas, Montana, and Utah. And it says these four states don't allow guilty but mentally ill verdicts. And in those states, the defendant is determined to be not guilty by mental disease. The defendant may then be committed to treatment until deemed sane. But there is no defense for it. There are three types of ways of determining whether a person is insane, and I'm going to briefly cover them. There's the Norton rule. That's what it says, M. Norton, but it's called Norton. The Durham rule, and what we call the substantial capacity test. that was established in what we call the Model Penal Code. And the Model Penal Code was a code that was set up to make it uniform across many jurisdictions. However, each jurisdiction still has the right to determine their rules. So let's talk about the Norton Rule for just a few minutes here. So in the Norton Rule, if an individual is deemed to be insane, they must prove these two elements: that at the time that the offense or murder, the defendant thought they were like stabbing someone with a knife. When he was starting stabbing someone with a knife, he thought the knife was a straw. Or at the time of the offense, the defendant knew that they were stabbing someone with a knife, but for any reason, as a result of a mental condition, they thought there was absolutely nothing wrong with killing the victim. So it's not just basically not right from wrong, but your mindset is so disguised from appreciating right from wrong. Not because of alcohol, not because of drugs, but it is a actual mental capacity. And here's an example here. So therefore, if a person thought that they were stabbing someone with a knife, then in that case, then they would probably be found guilty, not guilty of insanity under Norton Rule. Again, a very difficult burden. Now, let's look at what the Florida statute says. It says, and like I said again, it's at the time of the offense. The defendant had a mental infirmity, disease, or defect, which basically, because of that, didn't know what they were doing or appreciate the consequences of what they were doing. Or the defendant knew what they were doing and its consequences, but didn't know what they were doing was wrong. And again, it's the kind of capacity that almost like a baby capacity, I mean a little infant baby capacity, that they don't know what they're doing is wrong. So that's how the Norton Rule works. Okay, we call it the right from wrong rule, but that's what it is. So that is not what my jurisdiction does apply. The Durham Rule, the next one, now they all going to sound kind of similar, but listen to the distinction and I'll try to point it out to you. The Durham Rule is very rarely used in the United States. In fact, it points out here that New Hampshire is the only state that uses the Durham Rule. So according to the Durham Rule, acts are the product of mental disease or defect excuses criminal liability. And the Durham Rule came about because of a case called Durham versus United States, a 1954 case, which criticized the right and wrong Norton Rule that I was just talking about a few minutes ago, saying it was too simple. So the Durham case decided that mental illness was more complex than just right or wrong. I kind of agree with that. And that some actions would be also the product of a mental disease. So in other words, it's not just saying you don't appreciate right from wrong, but that you have some kind of disease of the mind that blocks your ability to be able to recognize right from wrong. So it's a disease, not just recognizing right from wrong. I told you it sounds very close. And so it's easier to prove than the Norton Rule, and so it comes down to the simple question: Did the defendant know the difference between right and wrong that is expressed in the Norton Rule? It stretches that question. It stretches it out. So the difference between right and wrong is controlled by a mental disease. Told you it was going to sound very similar, but really it's not a big deal because, again, it's used in only, as far as I know, even now, the rule is still only in New Hampshire, and if it's still being used there. But the most popular rule that is being used today in most jurisdictions, including ours, is what we call the substantial capacity test. Now, again, this was codification to make it and remove the recognition in the Norton case that the person didn't know the difference between right and wrong. But just to say, forget that. And that's the movement. But rather to move towards the mental disease aspects, saying that because of the mental disease at the time of the offense that the individual had, then they lack substantial capacity to appreciate the wrongness of their conduct and to conform to the requirements of the law. Sounds like right, wrong, but no. It's more like a standard of a reasonable person in terms of operating. Now, even that is difficult to prove, as you're going to see in a few minutes. I already told you that the mental disease or defect has to be there. Now, an example of substantial capacity is in this Wisconsin statute. It says a person is not responsible. In other words, they're off the hook if at the time of the conduct, the mental disease or defect the person lacked of theirs. The key word is substantial capacity, either to appreciate the wrongfulness of their conduct or conform their conduct to requirements of the law. So it's important to know that everybody is presumed to be sane. That's the standard. And so the defendant has the burden which shifts to them to prove that with evidence that they were operating or lacked substantial capacity at the time of the offense. Okay? So states vary how they also have interpreted that. And so the burden of proof to be successful is by preponderance of the evidence or clear and convincing, not beyond a reasonable doubt. So that's a benefit to the defendant, but even if it's that, it's still not easy. I would say this to you, that a person who commits an offense under either of these tests, but especially under the substantial capacity test, if they did any kind of planning or plotting to do it, or if they attempt to conceal or hide something, they probably are not going to be successful. And that's what we lawyers found out over and over and over again, as the court will look to see if the individual, and there's a special hearing set up where the court determines whether or not the person meets the standard of the jurisdiction in which the case is tried. And if they find any way, like for example, the one I had with this individual, he raped the young lady, he tied her up, stabbed her multiple times, put her in a garbage can, rolled the garbage can out to another location, hid the underwear under his mattress, cleaned up the stuff and all of that. You see that? He didn't fit it. Even though the act was heinous, it was like egregious, but it didn't fit the standard of the substantial capacity test. So you kind of see is that, you know, it's like a person doing something, because what this Hinckley guy did was he shot and then he didn't try to run. He was just apprehended and so forth. And it wasn't a person was on drugs or alcohol or anything like that, because those things don't do that. That won't work. So the final thing I'm going to say is in this last paragraph, and you'll get it here. You pretty much should have it now. But when a defendant wishes to pursue a not guilty by reason of insanity, I said there's a separate hearing that takes place. The state has psychologists or psychiatrists, and so does the defendant, if they're able to afford it. Most of the time they're not, and so the state appoints a psychiatrist or psychologist. We had a Dr. Rasmussen at the time when I was practicing in Cook County, and that individual examined the defendant and provides testimony to the court to guide the court as to whether the defendant is sane or insane. In some cases, will render the verdict, but not in a lot of jurisdictions. Of course, if deemed insane, then you know what I already told you. You go to a mental health facility, and the person is deemed until they deem no longer mentally or ill or dangerous. And so most individuals spend the rest of their lives in these hospitals, or either an extended period of time in the hospital. And that's the insanity defense, okay? Involuntary intoxication. Now, involuntary intoxication is a situation where it means it's involuntary. It is an affirmative defense. So you say, yes, I committed the offense, but I was operating under the influence. You didn't take a drink purposely, but something happened that caused you to become intoxicated. So here's some examples. The state of Michigan has a statute that under the influence or impairment by alcohol or drugs, if it's used as an affirmative defense, it is an affirmative defense to a specific intent crime. That is the ability to have the mental capacity to recognize and knowing the crime, for which the defendant has the burden of proof, and there we go, preponderance of the evidence, that he or she voluntarily consumed, illegally obtained, and properly used medication, and did not know, and reasonably should not have known, that they would become intoxicated. So let's say, for example, you drink something that is an additive is given to it, then you probably will find yourself in a situation. So you drank something that you reasonably would feel or know or should know that it would not get you drunk or render you to be intoxicated. Most of the time we're talking about people like giving somebody a Mickey, or in the instance where a person may have taken medication and didn't realize, and you know what, a lot of medications have warnings on there. But let's say, for example, a person has taken that medication and has been able to operate for years and years and years, but that somehow or another they inadvertently took 2 doses, forgot they took a second one, and took a second one that day or shortly after. Then in that case, by preponderance of the evidence, they have to prove that they did not know it, or it was done not on purpose. You kind of get the idea here. Stopping at a bar, taking some drinks and going out, that ain't going to do it. Stopping at a bar and maybe drinking what I would drink, which is a soda or a ginger ale or soda water, and somebody puts some kind of substance in it, or you drink something and you think it's water, and then it turns out that it's not water, it's something else. Of course, I'd say if it's vodka or gin, somebody would, the prosecution would probably come back and recognize the fact that they have odors and that you should know that that's not something you should drink. So it's not easy either. So let's look under what Kansas says. The fact that the person is charged with a crime was in an intoxicated condition at the time. Remember, the key is always at the time of the offense. Can be used as such if the condition was involuntarily produced. That's like what I was talking about earlier, like a Mickey or something like that, and rendered such person substantially incapable of knowing or understanding the wrongfulness of their conduct. So it kind of like does the same thing as the mental illness that takes place in insanity, but is triggered by drugs or alcohol that a person takes. Okay? All right. So it says here that the intoxication defense can be applied in those cases where a criminal law that was violated that had intent, the state of mind. For example, didn't know the difference between right and wrong. Remember, sounds familiar? And the fact that one was involuntary intoxicated negates their ability. The key thing, involuntary means what it says. Okay? Here's what I was talking about. Involuntary intoxication may happen if a person has their drink spiked or they have an unforeseeable adverse reaction to something lawfully prescribed. Okay? And then they give an example here. All right. So those are the situations for it. All right. The mistake of fact or law, we got two more areas to cover. The mistake of fact. Now, someone commits a crime but misunderstood the fact that negated the element of the crime. So remember, ignorance of the law is no excuse. But let me give you an example here, and you can see it by this. This is a really good example, this statute. A person is not relieved of criminal liability because they engage in such conduct under mistaken belief of the law, unless, follow what I say after unless, the mistake negates the existence of the mental state required by the offense. So under the Missouri law, like other mistake fact statutes, defense can be claimed if mistaken action is related to an element of the law in question. Again, let's use this example because it actually brings the mistake of fact here. So Lisa makes a large purchase of home goods store at a home goods store, including a push mower and a large box, which she puts at the bottom of the cart. The top of the cart is filled with items. She pays for them. She's distracted by her cell phone, doesn't pay the clerk, pay attention to the clerk to ensure that all items were properly scanned. She pays in a large bill or with a debit card and exits the store. She's then stopped in the parking lot by the loss prevention officer, who tells her she didn't pay for the lawnmower. Well, the loss prevention officer calls the police and requests that she be charged with that. Lisa would probably be able to say, oh, it was a mistake. And in this case, she had every intent to pay for that merchandise. That is, she had an intent not to steal, you see, but the clerk neglected to scan it. So in that kind of situation, not that she said, oh, I'm not going to do this. I know a lot of times we go to Walmart and we have groceries in the cart, and then we'll get the big case of water and we'll put it under the bottom. You know, under the bottom there is a spot under the bottom that you can put, and we'll always remind the clerk we have water in here. And so if you were to roll out of the store without paying for the water, it could be one of these type of situations that you say, oh my God, I forgot. And if you're stopped by them. But the point of the matter is that it wasn't an intent at the time of the offense for the person to steal it. That's the key. All right? Make sense? Okay. The mistake of law. Now this is a very interesting one. Hardly ever used, in which you claim that you violate, that if a person violates a law, but believe that their acts were legal. Now, that's not the same as ignorance of the law. Now, because people should know the laws that exist in the area. Mistake of law is applied in the scenarios that I'm getting ready to point out to you. A person relies upon the law, and later it was found to be unconstitutional. So it wasn't the ignorance of the law is found unconstitutional, then that is a mistake of law, because it was not it was unconstitutional at the time, but it wasn't determined to be. But later it is. A person acted in good faith to follow the law, but didn't apply it correctly. Now, that's not the same as ignorance of the law. It means you just don't know how to apply it. You thought you did. That's why people should have lawyers and not be your own representative. A person acted upon the advice that was given by a person or an agency responsible, such as a police officer or someone, and then it was wrong. That person relies upon that official or agency, and that's a mistake of law. A person commits an act contrary to law that has yet to be published. In other words, it's not even generally recognized or known that the law exists. So under North Dakota statute, mistake of law states that a person's good faith belief, and good faith is the key here in this, that conduct doesn't constitute a crime, could be an affirmative defense if they acted in a reasonable reliance upon a statement contained in a statute, a court decision, an order, or an official interpretation by a public servant, like what I had talked about a few minutes ago. So you should be aware that there is no reference to the ignorance, but rather permits the defense if mistakes are made. So it gives a scenario down here that brings it right home, and says if Paul had a suspended license and wanted to drive their ATV to work, Paul's mother called the sheriff and asked a sheriff deputy if it was legal to work even though his driver's license was suspended, and he was advised he could operate it. And then on his way to work, he was stopped for speeding with the ATV and cited for driving with a suspended license. Well, Paul then, of course, the burden would be you have to prove that you got that information from there, so it's pretty hard. Paul would be guilty of convicting while suspended, and the trial court didn't permit the jury to consider a mistake of law defense when rendering a decision. Paul appealed, and the decision was overturned. And the appeals court judges said that the trial court made a mistake. The mistake of law should have been a permissible defense. So in this case, Paul only drove his ATV because of some bad advice by a deputy sheriff charged with enforcing the law. The problem or burden would be you have to have that individual to say it. If they say they didn't say it, it's your word against their word, and you know what that's going to end up being in most cases. The final thing is a big area, a popular area that's used by many lawyers, including myself. I used it in my very first case, in a double murder case that was successful, and I used it many times, in which self-defense laws presume that the person committed the offense, again, raises as an affirmative defense, admitting that they did it, is that it involves several different ways. For example, someone, okay, let me just read what it says. The burden of proof is upon the person who used the force to prove that, as I told you, by preponderance of evidence, that there was interference against them or someone else. An unlawful interference can be being punched, shoved, kicked, grabbed, strangled, held against one's will. The point of the matter is that the amount of force would be the same force that is necessary to stop them. So, for example, let's say if a person is punching someone and you take out a gun and shoot them, or you might be charged with excessive force. So the whole thing is that it must be reasonable under the circumstances, all right? And so here's an example right here. Bob is walking on the sidewalk with Margaret, and they're approached by a drunk man who threatens to punch Bob. Bob attempts to avoid conflict and, says, keep walking, and the man shoves Bob and draws his fist back to hit him. Bob punches the man instead, and he falls onto the ground. Bob, upset because the man had just tried to assault him, jumps on top of the man to beat him until he becomes unconscious. Margaret pulls Bob off of the man. Now, he was okay until he jumped on the man to beat him until he was unconscious. And that's the whole point. So using our Illinois statute, a person is justified in the force against another when to the extent that they reasonably believe that it's necessary to defend another or protect themselves against imminent unlawful force. However, you are justified in use of force that is intended to likely cause death or great bodily harm. See, here's where we get to this point. Only if you reasonably believe that it's necessary to prevent imminent death or great bodily harm to you or to another or the commission of a forcible felony. So that's why Bob's use of force to stop the unlawful was justified. However, he went beyond that when he beat the man. And so it would not so. All right. And in most states, that's pretty much how it works. Now, many jurisdictions have now the stand your ground, such as became famous because of the Trayvon Martin case in Florida, which doesn't require a person to retreat. There used to be a duty to retreat. I always thought the duty to retreat was ridiculous, but or use a way of escape. But the stand your ground says that the person doesn't have to retreat as long as they're in a place where they should be lawfully and the attack occurs before using force, though, to stop the unlawful interference. Okay? So the individual cannot assert to stand your ground if they're committing a crime when they are attacked. Okay? So it is how it works. So the duty to retreat state would be a problematic situation when it comes to stand your ground. Now, the question that in the Trayvon Martin case is that the police told I can't remember the guy's name, but you know who I'm talking about, to don't go and pursue the Trayvon Martin, but he instead disobeyed the court order, the order of the police. Then in that case, I would say he didn't have stand your ground as a protection. However, the jury did decide that he did. So again, get an understanding that therefore individuals cannot assert a stand your ground if they're committing a crime. So if you go against what a police officer says to you, are you committing a crime? My thing is yes. But the jury, not the judge, said no, that he was in fear of himself. So, all right. Battered women syndrome. This is a situation that comes about very simply without reading all of this. It involves an individual who's been subjected to domestic violence on a constant basis. And what happens is that individual has been so inundated by the beatings that they've been subjected to that they raise a defense that the reason they took actions against the person finally was enough. And it's used to justify murder of the abuser or the victim. Now, the battered women syndrome is a mental condition or extreme emotional state that comes about because of the cycle of abuse that an individual suffers in domestic violence and is used in conjunction with self-defense laws. Now, the problem is that if you do so in a situation, okay, let's give this example because it gives it clear, and it's almost like the one I was going to tell you. That is one I'm really familiar with from my professional experience. Battered women syndrome was claimed in instances where domestic abuse victims believe that they are in imminent danger, and to escape the relationship, they resort to violence, including deadly force, as Diane did. Diane's been physically abused and battered many times by Jim, her husband, over a 10-year period. Each time Jim is drunk and she's battered, and the worst, she's been knocked and choked unconscious. One night, listen to this, Jim comes home drunk and they start to argue over Jim's drinking problem. Sorry about that. Phone never rings. Thought I had turned it down. Jim began to argue with her. Jim began to escalate. And Diane, because of the previous occasions, fearful that she'll be substantially battered again, she shoots him. So she's going to argue self-defense in conjunction with that. Now, you should be aware that that's a 50-50 case. First of all, number one, because of the situation, contemporaneously, he was heading in a direction, and she was under fear that she was going to be battered again. She shoots him because of the state of mind that she's in because of the previous beatings. That would probably be a good case. However, I would try this case not in a bench trial, but in a jury trial. And in my jury, I would want, you know it, females on that jury, as many as I could get on that jury. And so the bottom line is this. Now, let me tell you about a case that I know of where the battered women syndrome didn't work very well. And if I'd have represented the young lady, I believe I could have probably won it. Young lady I've knew since high school, and she was actually, her and her husband were my clients in real estate deals. Well, anyway, he was really violent. He used to beat her. She was afraid, you know, even to laugh and talk with me because I'd see the look on his face. Well, she became a battered wife. Well, she got tired of being battered, and she waited for him to go to sleep and then shot and killed him. The defense went out the window because she had a chance to get away, but she took it in her own hands and killed him. Now, if it was in the heat of him beating him like the way that Diane did it, then she'd have a stronger case. And so the key is, if you are doing any, if there's a period where the person is finished with it and then you try to kill them, you kill them, then you're probably going to run into a problem. So it's going to determine by a case-by-case basis. I believe that a lawyer could put enough evidence together, even in her case, because of all the circumstances that happened in there. But the problem that resulted in her conviction was because it was felt that she didn't have to kill him that time, which was kind of lame in my opinion. And she did serve a number of years in prison, and she later got out as it was. So that's how the battered women syndrome works. You can take a look at this video at your own leisure, and you can learn more about that. Okay? The castle doctrine, you know what that is, right? A man's home, which doesn't mean just a man, is their castle. That applies to any dwelling, a home, a business, a car. And what it says is that it says pretty much that a person can use reasonable force if they are under fear of great bodily harm or death, and someone enters their castle, their space, and then The person against whom the defensive force was used was in the process of unlawfully or forcefully entering, or let's say, for example, somebody's trying to jack your car, somebody's trying to break into your house, and something like that, or along those lines. Then if you kill that person, then the castle doctrine would apply. Okay? The person who uses defensive force knew at the time to believe an unlawful and forcible entry was taking place there. Okay? Now, Kentucky statute says the reasonable fear of imminent peril of death or great bodily harm to a person within the protected area is presumed. Therefore, the deadly force is justified to stop the unlawful intrusion. It's also important, as it says, to note that the castle doctrine statutes also have exceptions with them to prevent misuse of the deadly force. And so, as given here in the Kentucky statute, the castle doctrine doesn't apply when the person against whom the force was used was a lawful resident or had a right to be in the area, okay, such as an owner, renter, title holder, and there is no injunction that prevents them from being there. Or the person to be removed is a child or grandchild or within the custody of the person who is used. Or the person using defensive force is engaged in an unlawful activity or something. The person also against whom the force used is a police officer. So you can't use castle in that basis. You might argue, oh, I didn't know the person was a police officer and that kind of thing. You still might have some issues there. So those are exceptions. So jurisdictions vary. Okay. The final thing that I want to talk about is use of force by police officers. So you're going to be in law enforcement, and it's very clear that you understand that the standards are not as rigid as to citizens. For example, a police officer is allowed to use reasonable force to effectuate the arrest of a person, sometimes like hitting the suspect to take them into custody, but just so the force is reasonable to make the arrest. So if you're going to shoot somebody, are you really trying to make an arrest? I don't think so. So the officer will not be charged with battery. In contrast, if a citizen does that, then they could be. But anytime a police officer uses force, there is usually an oversight committee. We have various jurisdictions that have review boards to determine whether excessive force is used. And then when it's deadly force, it's really looked at very carefully, because the deadly force is based upon a few cases, one of which is Garner versus the United States, which I'm not going to go into. But the police can use deadly force when necessary to protect an individual, protect themselves, or if the person is in the process of committing a felony, a violent felony, that is, and so it's very limited. Now, if a person is running and the police doesn't want to chase them and they don't have a very serious weapon, then if that person shoots them, it's not going to be self-defense. It's not going to be self-defense, and it's not going to be justifiable force. And so there are a number of those that play out. I'm not going to go into detail, but be aware, if you want to take a look at these clips, you can take a look at your own time. But as you look at these clips, ask yourself, did reasonable suspicion exist for the stops that were made? Were the officers appropriately using deadly force to protect someone, to stop someone that also was using deadly force or apparently using deadly force? Says when the African American male, if you saw this in the clip, is stopped and says, "Don't touch me," could he have lawfully resisted because he was being attacked? Those are arguments that are presented. The key thing to remember is that the officer must use the commensurate amount of force that's necessary to stop the person, and in some instances when it's necessary, if they have a weapon apparently. I had a person one time, I was a police officer, pull a gun on me. Turned out to be a toy gun, which I didn't shoot them and kill them, but if I had shot them, and then later it was determined it was a toy gun, I was in my right to use deadly force because I was in fear of being killed. However, I did not do it at that time. But that's kind of like the standard there, or protecting someone else, or someone committing a violent offense. Okay, so those are the terms that I want you to be aware. Now, to get ready for the exam, again, key terms. Use the flashcards. Click on that and get this opened up if you find that that's not the case. Okay, and then you want to, let me move. Oh, there we go. When someone commits a crime, but misunderstood some fact that negated an element of the crime, we call that mistake of fact. So you can study that. Okay. Next one. A legal concept that permits people who are occupied within their dwelling to use deadly force to stop the intrusion. The presumption that deadly force was used to prevent great bodily harm, you already know, is the Castle Doctrine. Defendants may admit that they committed a crime, but the law provides an exception for which they will not be guilty despite their admission. What do we call that? An affirmative defense. And we told you self-defense, dealing with involuntary intoxication and things of that nature. Then the last one to do, the type of affirmative defense, including use of force, self-defense, defense of others, and deadly force that justify the otherwise lawful action. We call that justification defense. So you want to go over these and study them. There's about 13 of them. Okay, I tell you, if you use them, you'll be okay when it comes to helping you to get ready for the exam. Remember, I've been saying all the time, make sure that you look at those. Okay, move you over there. Okay, now let's go back down. Scroll down one more time. And then practice. You go over this, just click on that, and then you go over the scenario. Start the activity. And then, you go on. Jane has a white cat named Snowball that wears a pink collar and is let outside. One day the cat doesn't return. A few days later, while looking for a cat, she finds Snowball and brings her home. However, later that day, she realized that the pink collar has a tag that had the name Princess. Jane contacts police, but she fears that she'll be arrested for theft. This is a mistake of what? Mistake of fact. Okay? So then, Eric waves down a police officer and asks, "My landlord locked me out of my apartment, can I break in and get my stuff? The police officer responds, go right ahead. It's your place. Eric breaks in, and the landlord demands to be arrested for burglary. It's going to be a mistake of law because, remember, the police told him it was okay. All right? So that's how those work. All right? So you go through those as well. Moving right ahead, down to the, and we're a few minutes over, but just hold on. So now we're down to the practice quiz. Very, very important. Don't just do the practice quiz, by the way, because the other thing will help you as well. So this is what the quiz looks like. You already know because you've had one. So you are defending a case where the defendant, Derek, is accused of killing his friend during a schizophrenic episode and believed he had to kill his friend because he was the devil. You don't believe that Derek knows the difference between right and wrong at the moment. Whatever test would be most applicable. The Norton rule, not the substantial. Don't be tricked by this, because that is what I was getting ready to tell you. You don't believe that he knew the difference between right and wrong. And so the rule or test, what you might think is, nope, the substantial capacity test, is contrary and removes it. So it's really the Norton rule, okay? So anyway, you have to read very carefully, and I showed you that way because I wanted you to understand how it works, okay? So if you would have hit Norton, it should come out okay. Yep. All right. So that's how you want to go through all of those practice questions. Okay, that is it. And I want to go back and again remind you that you have the exam coming up. Make sure you study hard for it. The course, I hope you've learned a lot. I hope you've enjoyed it. And I hope to see you in other classes in the future. The word that I want to give you is self-defense. That's it. So I want to thank you for attending, and I also want to thank each of you for taking part in this class this quarter. And again, I wish you best towards your education and your future career in law enforcement or whatever aspect of criminal justice that you need. I'm going to say good night at this time.